Hi everyone, welcome to today's webinar. Thank you so much for joining us. I'm Alice from TUC Education and we're joined by Tim Sharp today, who is our Senior Employment Rights Officer at the TUC. He's going to be giving an update on the job retention scheme. And before we start, just to let you know, we are offering live captions on this webinar today. You should just see a green button that says live captions at the bottom of your screen. If you click here, you'll be able to access them. And also you should just see the chat bar running down the side of your screen where you can say hi and chat to everyone else on the webinar. And if you've got any questions for Tim today, you should see an ask a question button at the bottom of your screen where you can post questions there. Finally, we're recording the webinar today and it will be posted on our YouTube channel and on Crowdcast after the event. Brilliant. We'll start with Tim giving a bit of a short introduction and then we'll move to a Q&A with some of the questions that you've posted so far. Brilliant. Thank you, Tim.
Hi, and thank you everyone for logging on this afternoon. My name is Tim Sharp. I'm the Senior Employment Rights Officer at the TUC. What Alice asked me to talk about is the two sort of key government initiatives, the Job Retention Scheme and the Self-Employed Income Support Scheme. Both were introduced after significant pressure from the TUC and affiliated unions and are aimed at protecting workers' incomes during the massive economic shock we're seeing caused by the coronavirus pandemic and the shutdown. On the surface of it, the Job Retention Scheme is pretty simple. Any employer who wants to maintain their current workforce because their operations have been severely affected by COVID-19 can furlough employees and apply for a grant that covers 80% of their usual monthly wage costs. Now, furlough is basically a term that's been invented by the government, but it means that the worker is not doing any work for their employer during that period, but sort of remains on their payroll. Our priority, the TUC's priority in the early days of lockdown was to get the government to launch the scheme as quickly as possible. We were hearing of sort of huge layoffs coming from across the country and knew that unless something big was done quickly, we would see sort of vast job losses, widespread hardship, and an economy that was crippled. So this scheme was first announced on March 19th. We got more details a week later, and it began taking applications on April the 20th. The result, though, of that kind of reasonably quick announcement was we've seen constant tweaks, refining, clarifying of the scheme, which has meant quite a lot of uncertainty about exactly who it covers, for how long, what pay is covered, and things like that. And there have been significant amendments to the scheme as we've gone along. The government got into a habit of producing updates to its guidance of late in the evening, often on a Friday, which was a great joy to those of us paid to examine this stuff. And to be fair, the government, they have been reasonably responsive to concerns raised and clarifications sought by the TUC and others. And undoubtedly, the scheme has been big. HMRC said yesterday that a total of 6.3 million jobs, so someone might have more than one job, have been temporarily laid off by about 800,000 companies, with claims totaling £8 billion so far. So we're talking about a quarter of employees now being on furlough, and it's given how high that number is, it's quite striking to think about what would happen to those jobs and those people had the job retention scheme not be in place. Another thing that's quite useful to remember, the job retention scheme, is that no changes have actually been made to employment law. Workers' rights are basically just the same. What this is a grant scheme to employers. The rules of the scheme are set out in guidance to employers and employees and in Treasury directions, which sort of sets out the legal underpinning of the scheme. And where some of the complications have come is where there seems to be divergence between different documents. So who does the job retention scheme cover? It's what the government calls employees, so not the self-employed, though some of them can access a self-employed income support scheme instead. But as you know, the definition of employee isn't always as straightforward as you might think. There's a group that are called workers, a category that exists in between traditional employees and self-employed. Well, they're captured as employees in this scheme too. So the government has said from the start it will pay out for anyone paid through PAYE, and has made it explicit that includes many what we might call atypical workers, so agency workers, those on 0 hours contracts, and people on fixed term contracts. They're included and they're eligible for furlough. In terms of the employers eligible to claim, this is cast fairly widely. Any entity with a UK payroll can apply, so that's businesses, charities, recruitment agencies, public authorities. But the government has said it doesn't expect public sector employers to claim because they're still receiving the same money. Many of them are receiving the same money as before. So one of the things that's caused great anxiety has been the cut-off dates the government has imposed to this. Initially, this was set at March 19th, presumably to avoid employers retrospectively claiming more people on payroll than they actually had. After significant lobbying by us and I think employer groups as well, this was pushed back to February 28th. But the wrinkle being that for someone to be eligible for furlough, they would have had to have their details sent on an RTI submission to HMRC by March 19th. So what has happened is there are, I'm sure some of you have heard from a number of people, and we certainly have, those who started a new job in early March, thought they were covered by the scheme when the government changed the cutoff date, but then it turns out through no fault of their own that they weren't included on an RTI submission in time, and they're understandably aggrieved. Crucially, the scheme allows employers to rehire those they made redundant in the early days of the crisis. They've also clarified, and this is something we pushed very hard for, was on those who have been transferred under TUPE or subsequently will be transferred under TUPE while the scheme is running. Initially, it looked like that would count as moving to a new employer and people would fall through the gaps, but the government has clarified that they can be claimed for too. There was also sort of particular problems with government guidance on fixed-term workers. Again, at one point, the wording was in the guidance was rewritten and seemed to exclude those whose contracts had ended after the lockdown was announced. And then in the last week or so, again, after sort of concerted pressure from the TUC and others, government's confirmed fixed-term contract workers whose contract had been ended could be rehired in a similar way to permanent employees. And this was of significant importance in those sectors with large numbers of temporary workers, like I guess TV and theatre, where a number of furlough deals had already reached. Other key details, while this scheme was initially sort of written as applying to those who'd otherwise have lost their job due to coronavirus, it's now very clear that those with caring responsibilities, such as parents, can be put on furlough. The guidance also says that those who are shielding can also be furloughed. The issue of consent has been much discussed as well. Crucial details that furlough can only be initiated by the employer. A worker has no rights to request or demand to be put on furlough. There's a question of whether written consent is needed, which has been the subject of enormous speculation amongst employment lawyers and union legal officers. The government guidance says that HMRC doesn't require written consent from employees to go on furlough, although there has to be a written record that consent was sought. And again, after we kept nagging them, the government's confirmed that consent via a collective agreement is also fine to allow access to the job retention scheme. But some employers and some unions still think the very act of agreeing to stop work for a period requires written consent. So this is something, if there's uncertainty, to take up with your own union legal officers. Now, how much can be claimed? The government says that employers can claim a grant equivalent to 80% of someone's normal wage, up to £2,500 a month, plus they can claim the associated employer NI contributions and pension contributions up to the level of up to the legal automatic enrolment minimum on that subsidised furlough pay. I mean, they can, and we believe where they are able to, should pay up to 100%. And there have been notable union successes in a number of employers in achieving 100% pay. Working out normal pay is not terribly straightforward for some workers. The government says this includes contractual but not discretionary bonuses and not things like tips. We pushed very hard to ensure that those who are paid piece rates, I think in some areas, like I think warehousing, for example, sometimes it's going to be up to like a third of the wage. We ensure that piece rates are included in normal wages. But there are still some areas of uncertainty. Now, how long does furlough last? Well, the rules say that each period of furlough has to be a minimum of 3 weeks. We had pushed for shorter periods. That would allow in some workplaces where it was appropriate, so 1 week on, 1 week off arrangements. The government wouldn't budge. But in some places there's still a 3 week on, 3 week off sort of system, allowing some workers to work some of the time. Initially, the job retention scheme was launched as a 3-month scheme. It was extended last month on our urging after we pointed out the employers who thought they might have to do redundancy consultations. If it's for large numbers of workers, we'd have to kick those off imminently, and you don't want to start a process that could be hard to stop. So it's now been extended to the end of June, but that does mean that we face another potential sort of cliff edge on May the 17th, where employers might again feel they have to start collective redundancy consultations. So we're pushing the government to keep the scheme going as long as lockdown persists. So I mean, this all brings us, I guess, to the sort of challenges that we still face. Those I touched on, those unlucky people who changed jobs in early March and fall between schemes. We haven't yet managed to persuade the government to include short-time working within the scheme. We argued that in some workplaces it could be better to have everyone working 50% of the time and on furlough for 50% of the time, rather than having half people at home and half people working sort of full pelt, for example. But the government has thus far said no to that. But what might change things is the next sort of big question, I guess, for government and for us is how do we exit from lockdown, and what does that mean for workers who are on furlough? This TUC has set out its views on how you manage the health and safety side of things. We also have to think about when people return to working outside the home, how does wage support work? For instance, I guess if you want to reopen a pub, you can't do it on day one, but if the employer has no money coming in to pay wages, how could it work? So maybe we've been pushing the government to consider sort of part-time sort of working as part of the solution. They are ensuring that people are paid for the time, still paid for the time they're not at work. So that's something that we'll continue sort of talking to the government about in the coming days. Before I finish this introductory bit, just a few words about the self-employed income support scheme. There's been a little bit of good news on this in the last, yesterday, in fact. Initially, the scheme was expected to open in June, and today the government, yesterday, the government said it will start accepting claims on May the 13th and start paying out by May the 25th. HMRC will begin contacting eligible self-employed people this week, it says, by email, text, and letter, and then applications will open in tranches, and then sort of launched an online eligibility checker tool. Now, that the self-employed income support scheme will provide a grant of up to 80% of profits, up to a maximum of £2,500 per month for self-employed sole traders and partnerships. It's important to know that people working through personal service companies, and I know in some sectors working through a personal service company was often a condition of getting a freelance contract, but those working through personal service companies are not eligible support for this scheme. Though if you work through a personal service company and pay yourself partly through PAYE, you might be able to use the job retention scheme for that bit of your income, though you can't claim for anything you paid yourself in dividends. To be eligible for the self-employed scheme, you have to have filed a tax return for the 2018-19 financial year as self-employed. So that does mean that newer self-employed people miss out. And this is a crucial point of difference with the job retention scheme. Your annual trading profits must be less than £50,000, and you must derive at least 50% of your income from self-employment. your trading profits are worked out by reference either to your profits in the 2018-19 tax year or average profits over the three years up to 2018-2019. But that £50,000 sort of limit, or that £50,000 mark is really important, because in a crucial difference to the job retention scheme, it's a sudden cliff edge, earn sort of £50,001 on average during those 3 years, and you're not eligible for support. So that's a brief overview of sort of where we're at.
That's great, Tim.
Any questions?
Thank you. Yes, we've got some questions that have come in during the webinar, and the first one is just on holiday. So can you confirm the situation regarding the accrual of holiday whilst on furlough? Sorry, did you get that?
Yes. Now, there's been sort of one notable change, I guess, to holiday rules in general since with the sort of coronavirus situation. So the government has said that workers have not taken all of their statutory annual leave due to coronavirus, and I'll be able to carry it over to the next two leave years. Which is a notable difference. Previously, employers said were told they had to ensure workers take their entitlement in any 1 year. Now, in terms of workers who've been placed on furlough, they continue to accrue statutory holiday and any additional holiday provided for under their employment contract. So that's effectively no change. In terms of holiday taken during a furlough period, holiday can be taken during a furlough period, but has to be paid at basically 100% instead of not the 80%. The 80% level that the furlough pays out at, and so it's based on the employee's normal rate of pay or the average over the 52 working weeks before that. But I think one thing is an area we do have to look out on, because in all its communications on holiday and holiday pay, the government has said it's keeping the issue on review. So it's something we have to be sort of alert to.
That's great. Thank you so much. And then we've had another question come in regarding TUPE, which you touched on earlier as well. So the question is, how will TUPE negotiations work with new employees whilst on furlough?
Yeah, so it's an interesting one. I mean, the TUPE rules sort of are designed to protect employees' rights when the organisation they work for sort of transfers to a new employer, and as part of that, employers must consult with employees through what's called appropriate elected representatives who could be trade union reps. And one of the sort of great uncertainties we've had, and basically until the last week or so, has been, what is the position, for example, of union reps who've gone on furlough? Can they still continue their duties, or would they be deemed to be providing a service for the employer? And would a distinction be drawn, for instance, between paid and sort of people do rep stuff in their spare time? We've now had confirmation from the government that reps can still do their duties while on furlough. So this should mean that when it comes to TUPE negotiators, that should, the rep should still be able to undertake that duty.
That's really good to know. And actually, one of the questions we've had come through as well is that obviously a lot of companies may be genuinely worried about kind of breaching the rules and then not being eligible for government money. So on reps being able to carry out their duties whilst they're on furlough, is there a clear government directive that reps can show their employees a document or something online to kind of ease any fears that employees might have?
Absolutely. If you look at there's a document there's two documents, and it's certainly one is the employer guidance on the job retention scheme. Maybe that's something we can circulate afterwards. That provides a lot of the detail on this, and that has been updated to set out clearly that reps can still continue their duties while on furlough. And it had been a big issue. We'd heard reports of, for instance, health and safety reps being kicked off calls with employers because they were on furlough and the employer didn't believe that they could continue doing those duties. So it's a really important and really useful clarification by the government.
Yeah, that's really helpful. We can post that link in the chat, or what we can do is we'll email out the recording after the event and we'll put a link into that as well so everyone's got it. That's great. We've had quite a few questions come through about agency workers as well. And one of them is kind of, what action can an agency worker take if their agency does not want to operate the furlough scheme?
Yeah, this is one of the really tricky areas of the job retention scheme. It says that, I mean, it's very clear, it says that an agency worker can be furloughed, but it also says that it's up to employers whether or not they furlough an employee. So it's an agency worker who's paid through PAYE can be furloughed, but in a sense, it's up to the employment agency about whether they do that. So an employer can just simply opt not to offer hours to an agency worker, just as they can, for instance, for a directly employed 0 hours workers. I mean, that doesn't mean that you shouldn't try. It's very clear that from the guidance, agency workers are eligible. And while there was initially some fuss, for example, some teaching supply agencies saying, "Oh, teachers cannot be furloughed over the school holidays." For instance, over the recent Easter holiday, actually, the guidance is very clear that they can. So it's an area where certainly workers' rights are relatively weak, but they are, agency workers are certainly eligible if they're paid through PAYE.
That's great. And as Tim said, it's definitely something that you should demand of an employer if you are an agency worker. And we've also produced some guidance on how to organise during coronavirus, which would be helpful to look at if you are in that position. We can post that in the chat as well and email out afterwards along with the other resources. Great. So the next question refers to pension contributions. So the question is, do pension contributions cease whilst on furlough?
So this is almost like an ideal question. I used to do the pensions policy job at TUC before moving on to employment rights. This is all my interest in just one question. This is a really good question. It's clear pension contributions do not cease. Now, what happens is that the employer can only reclaim from the job retention scheme the minimum employer pension contribution that they need to pay under automatic enrolment, which is 3%, effectively 3% of wages. Now, they might have to pay you more though. For instance, if they're paying more than 80% of salary, then their contribution will be more than the 3% of 80% that they can get from the government. If they're a member of a defined benefit scheme or a similar sort of pension scheme, they'll have to pay a bit more. And there might be scheme rules as well for other forms of pension schemes that says the employer contribution rate is higher than 3%. It might also be the case if it's a salary sacrifice arrangement where technically the employer pays all the contributions, they might still have to pay more than 3%. But the simple answer is employers are still having to pay pension contributions when someone is on furlough.
Yeah, thank you. And thank you to Victoria as well, who's just posted in the chat some of the guidance around annual leave as well, which is really helpful. Right, the next question is regarding national insurance. So does the scheme provide a national insurance credit to person's national insurance record for each week, similar to when you're receiving employment support allowance?
The way it operates is more akin to just getting your normal wages. So the employer gets a grant that covers the employer NI contribution, and the employee pays national insurance and any income tax due on their wages as they might otherwise, and their eligibility, their credits relate, as long as they're over the minimum thresholds, that their credits operate as they would when they were just doing working normally.
Okay, that's great. And then a lot of the questions we've had over this period relate to those on 0-hour contracts as well, which you mentioned as well. But What advice would you give to workers on zero-hour contracts that have been told they will no longer be paid even though they've been placed on furlough?
I mean, this scheme is very clear from the guidance the government has produced that those on 0 hours contracts are eligible to be furloughed, and it's set out a mechanism for working out how much those on variable hours should be paid. So it's to say that somebody is being furloughed but they're not being paid is not quite right. If you've been furloughed, you should be being paid your 80% of your normal wages, worked out on the way that the government sort of sets out how the calculation should be done. However, as I sort of talked about before, the weakness of the scheme is that if you're a 0 hour worker, your employer can simply decide not to offer you any hours. But unions, workers and unions should be demanding that they are being furloughed and they are being paid.
Thanks very much. The next question comes from someone who works in higher education, and they just want some clarification on how the scheme works for higher education institutions, which are essentially public funded, but there are still people in those environments on casualised and precarious contracts who are really very vulnerable at the moment. And what would your advice be to them?
This has been another sort of complicated area, because the government has said it doesn't expect publicly funded organisations not to be using the job retention scheme. We have had some more clarity about what that actually means for higher education, and the government is still trying to push institutions to access other government schemes, various sort of financing and loan schemes sort of first. But it has said that AT providers can furlough employees under a certain number of conditions. So the employee works in an area where services are temporarily not required and where their salary is not covered by public funding. So it'd have to be clear that their wages were coming out of alternative means of funding, that they would otherwise be laid off, that they're not delivering provision that's already been funded, and that this the job retention scheme grant would not duplicate other grants that the other public grants that the HE provider receives. So the government have made very clear it's going to be checking that there's no duplication of funding. So I mean, the short answer is yes. The higher education institutions will have to do a bit of work to show that particular person is eligible to be furloughed, but they can put workers on furlough. And I think there were certainly some indications early on in the lockdown that some institutions were trying to move rather quickly to sort of end contracts for sort of casualised workers within universities, and hopefully this is will mean that process will not have to happen, certainly now.
Okay, great. Thank you, Tim. I can just see in the chat there's a few questions come through about clarification on annual leave. So one question is just about bank holidays, which is obviously they happen a lot at this time of year. So should employees be paid full days for bank holidays while they're furloughed, or would they be given 80% of their pay?
This will depend on whether they normally have bank holidays off, but if you normally have bank holidays off, then you should be paid 100% for that day, and it doesn't break that sort of holiday day doesn't break your 3-week period or whatever of furlough. I mean, the tricky thing for the employer is they can only claim 80% back from the government, but as far as the employee is concerned, government's quite clear. Holiday days should be paid at the level of a normal earnings.
So holiday days should be at 100% of earnings. And we've just had one question as well from Rachel saying, can workers be told that their annual leave is deemed to have been taken whilst on furlough? It's a tricky one. The employers under existing
law effectively. Employers can tell you to when to take your leave. I mean, that might typically happen, for instance, during a sort of summer shutdown or a Christmas shutdown. And so if an employer wants a worker to take annual leave, then they have to provide notice of double the length of the leave they wish them to take. So if they want them to take a week's worth of leave, they have to give them 2 weeks notice. They can't just announce that the time you've had off was actually holiday. Now, I mean, I guess one of the ambiguities is that if an employer wishes a worker to take holiday while on furlough, it must be sure that any of the restrictions that worker is under, like the need to socially distance, whatever, do not prevent the worker from resting, relaxing, and enjoying leisure time, which is kind of the purpose of the holiday. But I mean, the short answer is that nothing has changed under what the existing rules are, which are that the employer can require you to take leave under certain conditions. Okay. And they can also cancel holiday as well if they give the adequate notice. If they do not wish to pay you at 100%, they can give. If they give the correct notice, they can cancel leave too.
Okay, that's good. Thanks, Tim. And we've clarified, obviously, that furloughed reps are still able to carry out their duties and activities. But we've just had a question through that also asks, are reps able to contact members who have been placed on furlough?
It would seem pretty clear that they can. I mean, there's bound to be, unfortunately, in some workplaces, instances where we're going to begin. Employers are going to want to begin redundancies, and there's going to be a collective consultation process. And in those circumstances, the clarification we've had amongst reps is that reps can continue undertaking their duties, which one would assume would apply in that circumstance. And therefore, as far as we can tell, there would seem to be no reason why they cannot therefore contact members. They're not trying to induce them to do any work on behalf of the employer. So it seems reasonably clear. It seems pretty clear that can happen.
That's great. We've got time for just maybe 2 more questions. I know, Tim, you've got to get off and get your kids from school. But just one quite broad question, kind of looking into the future. Ida from GMB has asked, I'm particularly interested in any subsequent redundancies that may arise following return to work. It's quite an open question, but I don't know if you've got any thoughts on possible redundancies that might be coming.
Yeah, I mean, one of the things we're very keen is that this scheme isn't suddenly just ended. And from what the Chancellor said yesterday, he seems to indicate that's the government's intention as well. They won't suddenly find an end to the job retention scheme. But obviously, when there are large-scale redundancies, employers have to conduct a collective consultation process for at least 45 days, launching 4 or 5 days before, and so that all those provisions will still apply, and we would think that any redundancy pay will be based on normal earnings rather than furlough earnings, but we're going to have to double. That's one of the areas we're going to have to double check what the wording of the scheme is. But yeah, I mean, I think that's unfortunately what it's more likely to see these in coming weeks.
Okay, that's great. Thank you very much. I think that's everything for now. Thank you so much for joining us, Tim, and thank you so much for answering all those questions. That's been incredibly helpful. And thank you to everyone for joining. We will send out a recording of the webinar after the event, so you can get access to this on YouTube as well. There are a few questions that we haven't had time to answer, but what we'll do is we'll make sure that those are kind of incorporated into content that we're producing in the future, so we can provide any guidance on things that are still outstanding. But again, thank you so much for joining, and our next webinar will be Thursday, the 14th of May, which will be looking at health and safety in workplaces. Well, thanks again, Tim. See you all soon.
Thanks. Bye-bye.